Thank you. Just having issues with changing the page. Got it now. All right. Alexis, do you want to start and say a little bit about yourself?
Sure. Hi, everyone. Good morning. My name is Alexis King. I am a Title IX staff attorney with Rocky Mountain Victim Law Center. We are a 10-year-old or more now nonprofit, and we started with work around upholding victims' rights in criminal cases, and have branched out into doing Title IX work. We offer free legal services. There is no qualifications, and we represent children in K-12 and young adults in university settings as they go through the Title IX process and potentially onward into the Office of Civil Rights. We do not file lawsuits as part of Title IX nonprofit work, but do have a solid network of referrals for clients that go that route. So that's a little bit about me.
Thank you. My name is Rebekah Ottenbreit, and I work for the Colorado Department of Education. Like a lot of district people who have Title IX as part of their charge, I wear multiple hats. I was actually hired at CDE as a full-time English language development specialist. Prior to coming to CDE, I taught K-12 English language development for about 20 years in multiple districts across Colorado, as well as overseas. And about 3 years ago, I was asked to take on this role of Title IX state coordinator. My office, the English Language Development Office, it actually has a longer, fancier name, Culturally and Linguistically Diverse Education. We are part of the unit of federal programs. And as most districts that are on the line know, districts and schools that accept federal funding do have to comply with Title IX. And so that falls under our purview. And I've really enjoyed learning a lot about Title IX and supporting schools, districts, students, and parents around Title IX. I do trainings for districts and answer parent and student questions, district questions, provide technical assistance, and happy to be talking with you today. So I want to thank you all for submitting your questions prior to today's panel. We did have a lot of questions, and we're going to try to address as many of them as we can today. These on this slide are kind of the big picture, overarching questions. A number of you said, I really just want to know what the changes are and what the compliance requirements are for K-12. Because the new rule talks about both K-12 and university. And so, you know, some support in teasing that out. Also, you asked for practical ideas and best practices, how you can build and maintain structures that would support both students and staff. And so these are our overarching goals for you today. And I always like to start out with the Title IX statute. This is from the Education Amendments of 1972. And the statute itself is just one sentence saying that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. However, I'm sure a lot of you have learned over time that there are a number of things that fall under that umbrella of sex-based discrimination. On the left-hand side, we have prevention and response to sex-based discrimination in different areas, such as athletics, supporting pregnant and parenting students, how to handle single-sex classes or schools, and how to provide STEM opportunities to the underrepresented sex, which historically has been women. On the right-hand side, we have the prevention and response to sex-based harassment. And there are three things that historically have fallen under that umbrella of sex-based harassment. I apologize, that fourth green bullet should not be a bullet. Historically, under Title IX, sex-based harassment has included sexual harassment, sexual violence, and gender-based harassment and bullying. So over the years, there have been follow-up rules, regulations, and guidance that have come from that one sentence about Title IX. In the 70s and early 80s, implementing regulations were issued to explain how you fulfill that one sentence statute. Those are 34 CFR, Part 106. And then following that, there were a number of guidance documents that came out over time. The guidance documents, you've probably seen over the last few years, guidance documents that have been issued, other ones that have been rescinded. Guidance does not weigh as heavily as rules or regulations. And so this current administration, part of their criticism of the previous administration was that they issued guidance rather than going through a rulemaking procedure. And so that is what this administration did. They went through a rulemaking procedure. And this new rule is specific to that right side of the umbrella, the green umbrella, sexual harassment. It is in addition to and not instead of the 34 CFR implementing regulations. In order for it to be considered rulemaking, they had to go through a public comment period, which was held at the end of November 2018 through the beginning of January, the end of January 2019. And they did have to address all of the submitted comments, which could explain the lag between when the public comment period occurred and the final release of the document, which was just at the beginning of May. It is rather long, at 2,033 pages. We will do our best to unpack it for you, but keep in mind that we won't be able to cover everything in a 1 hour panel. And those regulations do go into effect August 14th. So I just want to start out with some practical ideas of how you can digest this long rule. I would start out by establishing a Title IX team. You're going to want to include your district attorney, and if you have a district policy writer, or if there is an organization whose policies you tend to adopt, I know that there are organizations out there that write policies for districts. You're going to want to include those people. You also want to include your implementation team, or the people that are actually going to have to enforce Title IX, because they're going to have some practical feedback for you about logistics, what works, what doesn't, how can we make this happen. The document has a table of contents at the beginning, and if you're looking at it on the computer, you can easily use Control F, search function, to find things that you need. I find that to be an easier way to read and digest the material than just reading it cover to cover. And finally, know that every district is in the same boat, and so you certainly can reach out to other districts for their ideas on how they are proceeding. So with regards to the changes, there were a number of changes to definitions. And definitions are important because without them, everyone's going to interpret the meaning differently. I'm sure you've heard that there's been some criticism around this new rule. There's been multiple criticisms for multiple reasons. One of the reasons is this new definition of sexual harassment. The definition section is 106.30. And the U.S. Department of Ed's take on this was that they were wanting to provide people with consistency and simplicity in understanding what sexual harassment is under Title IX. In other words, what things do a school or district have to take responsive action on under Title IX? And so they've limited it to these three things. Quid pro quo, which is asking for sexual favors in exchange for special treatment in the classroom. Could be something like grades, extended time, basically a favor. Number two, they're using the court case of Davis and phrasing verbatim what came out of that court case, which was a sexual harassment court case under Title IX, and that is unwelcome conduct that a reasonable person would determine is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to education. Now, one of the questions we received is what constitutes as severe, pervasive, and persistent. This rule has not gone into effect yet. It doesn't go into effect until August 14th. And so I don't think we're really going to have an answer to that question until we see how this fleshes out. We see what lawsuits come up. But the most information we have right now is from the Davis court case that they cite, and the discussion in the rule, which is covered in pages 507 to 517. So I would refer you to those pages, to the Davis court case, and to your district attorney for a more thorough explanation of what is meant by that severe, pervasive, and persistent phrasing. Finally, the third definition of sexual harassment is sexual assault as defined in the Clery Act, as amended by the Violence Against Women Act, which is a single instance of dating violence, domestic violence, or stalking. Something to keep in mind, though, is the new Title IX rule does say that you can address other forms of sexual harassment that don't fall under this Title IX definition through your student code of conduct. So if this feels too limiting, those are things you are going to want to address in your student code of conduct so that all of your students are protected. The definition of actual knowledge has also changed. In the past, schools were told that they were responsible for Title IX violations that they knew about or reasonably should know about. I know some of the districts I've talked to have struggled with that part of, you know, what I should reasonably know. Sometimes I don't know. So I think that this particular change in definition will be helpful for schools in that actual knowledge is defined as meeting one of these categories. So basically a student reporting to any employee of an elementary or secondary school. This is different from how it was in the past, different from how it is for university. The student does not necessarily have to go to the right person, such as a Title IX coordinator. And you know, the reasoning behind this was that kids don't always know what a particular adult's position is in the school. They're seeing all adults as authorities, and all of those adults are acting in loco parentis, which means in place of parents. Also, school employees are typically mandatory reporters. They are in the state of Colorado. So a student reporting to anyone counts as actual knowledge. And then certainly an employee observing anything that would fall under that sexual harassment also counts as actual knowledge. We received a number of questions around education program or activity. And there is a new definition of education program or activity. It encompasses all of the operations of a recipient. So a school district is a recipient, the school itself is a recipient, whoever accepted those federal funds is the recipient. It also includes locations, events, circumstances over which the recipient has substantial control over both the respondent and the context in which the harassment occurs. These are the two big ideas. The question that comes up is then, how does that happen? How does that affect off-campus activities? So the administration does say that off-campus buildings that are owned or controlled by a student organization officially recognized by a post-secondary institution. So this is specific to university, but from a logical standpoint, if you have an off-campus building that is owned or controlled by a student organization and you're a K-12, there definitely could be an argument for that being part of your operations and something that you have control over. Whenever there's an off-campus type situation, you have to ask yourself if any of the above three conditions are met. If they are, then it's an education program or activity under this new definition. A change that came up is that this particular rule is saying that it must be in the United States. And the department basically gave some rationale around that. They cited the federal district court case of Phillips versus St. George's University. And their argument basically was about a study abroad program. One side of the argument is, well, the study abroad program is part of your program. However, the ruling was that Title IX does not have extraterritorial application because in the actual statute, it does say in the United States. From a practical standpoint, it might also be difficult, for schools to gather evidence and witnesses and address things that happen outside of the United States. However, do keep in mind that you still can address things that fall outside of this scope through your own student conduct policy. And you can still offer supportive measures for students regardless of where the situation occurred, even if the situation occurred outside of the United States. There were questions also about cyberbullying and whether cyberbullying was something that was occurring off campus. So the big answer is that it depends. You have to ask yourself if the cyberbullying was part of all of the operations of your school or district, and whether the school or district exercises substantial control. And so here are some specific questions you could ask yourself about whether or not you have substantial control. Is the device owned by the school? Is the harassment occurring during class time? Is the harassment occurring using the school Wi-Fi or school purchased software or a school email address? Is the harassment occurring on a school designated platform or website? Some other questions that I don't have here on the slide, but basically the overarching questions are really, is it impacting the child's ability to engage at school? We do have to keep in mind that online bullying often has repercussions at school within peer groups that could raise to the level of Title IX. You also have to go back to that definition of sexual harassment. Is it so severe, pervasive, and objectively offensive that it is effectively denying equal access to that student's education? Oops, got a little trigger happy there. So for districts in particular, one of the first things you're going to want to look at is updating your policies. These are some of the policies that you will want to look at. There might also be other policies that you need to look at. Now, policies are kind of overarching statements, whereas procedures are the day-to-day, how it happens. And so you're also going to want to update your procedures. Just some basic things that should be included in your policy and or procedures is the Title IX coordinator's contact information and name. And I have the S in parenthesis because sometimes there is more than one Title IX coordinator. If you are a school and you have your own school-based Title IX coordinator, there's also a lead district Title IX coordinator that oversees that person. You do need to include both in your policies and procedures. You're going to want to include the definitions because everyone's going to define sexual harassment differently if you don't include the definitions. If you have one definition for sexual harassment under Title IX and a different definition of other forms of harassment under your school code of conduct, you're going to want to delineate those. For the purposes of Title IX, you have to have the rights of both the complainant and the respondent and how the school will respond. You also want to include any sort of timeline, form that has to be filled out, or appeals process. Now, I know we received questions about the timeline. The department has intentionally given recipients flexibility to designate their own reasonably prompt timeframe. Basically, the requirement is that the grievance process includes reasonably prompt timeframes for concluding the grievance process, including any sort of appeals process, including any informal resolution process. They do allow for some temporary delays and limited extensions of time frames as long as it's for a good cause. But no, they don't define explicitly the time frame or the good cause. And at this point, I want to turn it over to Alexis to see if you have any other comments, Alexis, about the time frame.
Yeah, thank you, Rebekah. So I think that there's, particularly in the formal complaint process, a couple of hard time frames that must be observed, even though there is a lot of reasonableness and unknown time frames in everything else. The first is that there should be an opportunity to inspect and respond to information gathered. So once this formal complaint is being processed, there must be an ability for folks to go in, look at what is being discovered, and then give 10 days for folks, at least 10 days for folks to respond in writing. And then once the investigative report is issued, including kind of a summary of the evidence, that must be provided 10 days prior to any hearing or determination. So if you're not having a hearing, but there is going to be a final determination made without that hearing process, there still needs to be 10 days between the investigative report issuing with the summary and this kind of final step of determination or hearing. So those are two kind of firmly set things that need to be, people need to be mindful of. From an advocacy standpoint, there is a concern that this reasonableness in timeframes will be stretched and potentially abused by schools that are in a bad spot. And so, you know, there's also a potential where a school, I think, under these rules could kind of wait out a student and have them leave campus and then not be obligated to do much else with the Title IX process. So those are some things to think of as we're talking about timelines and really taking care of the issue at hand.
Thank you, Alexis. And sorry, I fast forwarded through the slides, so I'm trying to get us back on track. There's a bit of a delay and I got clicker happy. try again. All right. There are also new posting requirements. So under the previous implementing regulations and guidance, schools and districts had to post prominently on their website, particularly on the homepage, the notice of non-discrimination and the Title IX coordinator's name and contact information. It was recommended to post grievance procedures, but now under this new rule, it is required to post grievance procedures. Another new posting requirement is to post all Title IX training materials that were used to train your Title IX team, your students, parents, wider community. Over the last school year, some districts received an email from me regarding these previous posting requirements. And so I do want to talk to them because there were districts that were not in compliance with the previous posting requirements, and now there are additional requirements. So the first one, regarding the notice of non-discrimination, there are a few things that have to be included in that statement. Most of the districts that I looked at, their websites did clearly say that the district did not discriminate on the basis of sex. However, a number of districts were missing this second part, which is that any person may submit a question or file a complaint with the Title IX coordinator or with the Office for Civil Rights. So you'll want to look at your postings and make sure you're including those things. Also, while districts had this notice posted, oftentimes it was hard to find on a school website. So if you are the Title IX person for your school, you're going to want to make sure that you have these things on your school website as well. With regards to the Title IX coordinator's contact information, what I found missing most often was the email address and the name. Also for school, you want to remember that you are going to post both the school Title IX coordinator's name and contact information and the lead district coordinator's contact information and name. It's very important that parents and students know who the lead is, because if they have an issue with the school Title IX coordinator, they need to know who is the next person in authority that I can go to. Grievance procedures, like I said, were not required. They were highly recommended, and I know that if OCR visited your district, it kind of became required, but it is definitely now required. In my observation of district websites, I rarely found grievance procedures. They usually were hidden in board docs, so I guess technically they were there, but from a practical standpoint, your parents and your students are not going to be digging through board docs. The grievance procedures need to be easy for them to find. I would recommend putting a link to them right there with the notice of non-discrimination and Title IX coordinator's contact information. Likewise, I would recommend having a link to all of your Title IX materials.
I will be taking over for a couple slides now, and I'll just echo what Rebekah mentioned about the posting of grievance procedures and other information like that. As a lawyer who works in different parts of the state, we often are only finding that information by digging through board docs, and it is not where our families go to look. So that is something to keep in mind as far as accessibility goes.
Alexis and Rebekah, just really quick, there was one question to quickly clarify. These all should be on the website homepage or on the website generally, or just easy to find?
So I feel like I've read multiple things. So I'm going to let Alexis address that question.
Sure. We don't give advice to districts, but I will tell you as an advocate on behalf of kids facing sex-based discrimination, if parents can't find it and it takes a lawyer to find it, it's probably not in the right place. So it should be front and center without having to use a search function that takes you down a rabbit hole. That's not legal advice, it's practical advice, and I think it better serves the community that way.
Great.
And if I could add a comment to that, Alexis, I know that I've heard from districts that have had OCR spot check them, that they were told it should be at the bottom of every single page on their website, so that it wouldn't matter what page a parent or student is on, they could easily find it. And I know for CDE, that is what we have. We have a link at the bottom of any CDE page that says Title IX. And if you click on it, it will bring you right to the Title IX page.
Great. And just really quickly, another question. Does this apply to charter schools as well, particularly those authorized by a particular district? Do they need to post that on their website too?
If they're receiving federal funding, then the answer is always yes. And a charter school is under a district, so yes.
Thank you.
Mm-hmm. So we're talking a little bit about new roles and the role of parents in Title IX. The real heart of the new language and the then 2,000 pages of interpretation is really to cut down on kind of conflicts of interest and conflicting roles within the Title IX process. So oftentimes, I think practically speaking, people wore multiple hats, and that is actually very problematic when we're talking about improving due process and transparency and eliminating conflicts. So I think districts have to be really thoughtful about how they are assigning these tasks, because there must be a Title IX coordinator that is different from the investigator, that is different from the decision maker, that is different from the advisor, that the child should be able to have and access. And then likely different from a person who facilitates an informal process. So with that in mind, there's also then what other hat that person might be wearing. And so, for example, if there's a conflict because the Title IX coordinator is dealing with a staff student issue of harassment, but is also the HR director, that may be problematic for that person to maintain a conflict-free position as they go through the Title IX process. When we're talking about an advisor, which children can have access to, particularly in the formal process of Title IX or a formal complaint, I think there's a question about practicality. So we'll get into this a little bit more, but the child can have someone who can sit with them and help them respond in writing to the investigation process and examine evidence and all of these things. And that person is most likely, practically speaking, going to be a parent very often. But there's also a concern about, how that person can advocate from a position of what's in the best kind of what's serving that child. And sometimes parents will struggle in that position, especially as they come up against or maybe in conflict with all these varying roles within the school. And so I think there are different community-based advocates, and frankly, there's a whole nother training we could do on that that could be accessible, but there's also privilege and confidentiality that can come with other community-based advocates that could sit as an advisor. And so right now, there's an option for a lawyer to be present, and obviously I'm a lawyer and think that we can serve useful purposes, but that really is in a position to advise for that child that's going through the process in a way that is different than perhaps a parent or a community-based advocate that has other rules around confidentiality and purpose. There was a couple of questions submitted around this issue that we would like to address. One was whether or not school employees have to wait for parents to be present before questioning a student. And this is a really complex question. I'll try to address it briefly here, but happy if someone wants to ask maybe a more technical assist question. We are certainly going to provide our information at the end for contact and outreach. But the bottom line is, the first and foremost is the school investigating something that qualifies as a crime? And if the answer is yes, then I would hope that the school has a plan for how to handle that includes law enforcement, because the next questions are essentially, you know, have they been trained to do trauma-informed interviewing? Are they putting the child in a position of having to repeat their story multiple times? And are they, frankly, potentially jeopardizing the safety of the child by interviewing them in that space? The second thing to think about, though, in contrast, is that Title IX cannot wait for and rely solely on the work of the police. So there's going to have to be a procedure within the school to address the issue and to begin working on the Title IX piece, regardless of the status of law enforcement. All right. One other thing to think about in the Title IX process that I'm hoping that we'll come back to is that if you have an informal Title IX process, and obviously you're going to have a formal Title IX process, do you want that person who handles the informal process to be one of these people, the coordinator, investigator, decision maker? Because the bottom line is that at any point in time, the rules say that someone can opt out of the informal process and go with a formal process. And does that person then have an additional conflict having tried to work through the informal resolution process? All right, so the argument from this administration for making these such significant changes to Title IX was to improve the due process. So making sure that everyone has a fair opportunity throughout the Title IX, particularly the formal complaint process, to be treated fairly. So it begins with this idea of gathering evidence. So in a formal complaint process, the rule states clearly that the gathering of evidence cannot be put on the complainant or respondent. And that is difficult, I think, from a practical place of, well, if mom of either complainant or respondent tells you that there's 50 text messages between these two, and it sounds like it would be something that you need to make a decision and to examine it, you obviously need them to give you the text messages. I think what happens, though, in many investigations is that families feel incredibly overwhelmed, and then there's a concern that it's on them to basically present what they need to present in order for the school to pay attention, or let alone finding in their favor. So I think schools have to be very mindful of not putting the onus of doing investigation and doing research on either family. One thing that I have seen in my practice is the families give the investigator a list of possible witnesses, and then the investigator picks one or two out of that and then makes a decision. And I think that that is in contrary to the language around the new rules. Obviously, due process includes this idea of having conflict-free people involved in the complaint process, and I think people need to be mindful of that throughout. Like I said, mindful of whether an informal or formal, whether an informal process can create a conflict for the formal process if and when parties opt out. Reasonable timing. I have to tell you that as an advocate for those facing discrimination, timing is often ignored in Title IX, and not only by districts but also by Office of Civil Rights. And so there's a real concern that these processes are only going to get longer and more delayed. There's a lot of requirements about written notice about any hearings, and I think that that is generally across the board kind of a weakness, that there is not written notice provided to the parties about what's going on and what to expect next, including interviews, investigative interviews. Opportunity to inspect is, I think, still is going to be an obligation on K-12, and something that I think districts as a whole don't understand and have as part of their practice. And then there's also an obligation in the written findings to differentiate evidence, things that were considered and things that were not considered, and to be making that very clear. There is that 10-day response timeline that we talked about. Once there has been an inspection of what has been gathered. And then with the investigative report being issued, there being at least 10 days prior to any final determination. I think it's really important that districts may provide a hearing. Rebekah and I had a couple conversations about what this means, and I think that what will end up happening is that at some point there will be a lawsuit because either a hearing was or was not provided in K-12, and it will generally change the practices. Obviously, there's a lot of problems. There could be a lot of re-traumatization for a hearing with young people and untrained advocates and kind of a quasi-judicial setting. However, if no hearing is provided, then there is an opportunity to submit written questions by both sides to be answered through the district. And then once there's a written determination, there needs to be clarity in the appeals process. Also something that I think is often not clear, and certainly not something that districts have a lot of practice at. And so essential for it to be clear to both parties once they've gone through this formal process. Some differentiating between university Title IX rules and K-12. In university, coaches are not mandatory reporters, but coaches are apt to be mandatory reporters in K-12, and therefore if any report goes to them, they are on notice for purposes of Title IX. Cross-examinations and hearings may be available in K-12. It is up to the district to decide. And then for both, there is rape shield language, which basically means that prior sexual behavior is not relevant unless it points to another possible respondent, or if it goes to consent. And so that in this new kind of quasi criminal version of Title IX, it could be very difficult for districts to wade through, and frankly, very difficult for a child advocate who is unknowing and doesn't understand these more technical provisions to protect a child during a cross-examination or a written exchange of questions. And obviously the district would have to be very mindful to not engage in any questions that could violate that protection to someone who has faced sex-based discrimination in school. All right, so there was lots of question about informal versus formal processes, and the new language is not as direct about what happens in informal Title IX, but it is important to know that a district or recipient may not require the parties to participate in informal resolution under this section, and may not offer informal resolution process unless a formal complaint is filed. So you have to start down the Title IX path to engage in your Title IX informal process. All right, how must the school respond to a complaint? They must be prompt. Title IX coordinator must contact each complainant, offer supportive measures with or without a formal complaint, and explain the process for filing the formal complaint. In both parties must be treated equitably. So I don't know. Oh, whoops, sorry about that, y'all. And then if formal complaint is filed, you have to follow your procedures in order to be compliant with Title IX. And that's where we get to this idea that they have to be clear, that families need to know where to find them, and have an idea of what to expect. Supportive measures are non-disciplinary and non-punitive. They're individualized, they're appropriate, they're reasonably available, they're free, and no formal report is required. So a lot of times this can put and seem to put a lot on the complainant. And the reason is because often they are the ones who are fearful, distraught, and they may just want to go to math class without the respondent being present. In our experiences, often any schedule changing that impacts the respondent is seen as punitive. And I think that that is going to have to be something that districts have to resolve as they work through these things, because there still needs to be safety plans in place. And so the language around not putting the entire burden on the complainant is still relevant. And obviously, if even if the complainant is the one who is feeling like they're safer to just not maybe participate in a program or in a class or even at the school is still, it's still incumbent on the school to try to make the program, the class, or the school available and safe for the child to engage with. So here's where we talk a little bit more in depth. Course-related adjustments could change when exams are taken, an opportunity for an academic transcript adjustment, counseling either inside the school or outside the school, again, free of charge, deadline extensions, modified work or school schedules. The rule includes the idea of changing in work or housing locations. That's obviously geared towards higher ed, but I think that gets to this idea that if there is an adjustment like changing classes, that should be considered as one of these interim supportive measures that a school should consider, so that both the complainant and respondent can still access their education. So if we go all the way through the formal complaint process and the respondent is found responsible for sexual harassment, there has to be a written determination, and the rule actually is very specific about what must be included. Having worked in different areas around the state, oftentimes, any kind of written determination is rather brief and does not engage in the analysis I think is required by the rule. So there has to be an identification of the allegations, description of the procedural steps that were taken, interviews, site visits, any methodology to gather information, any hearings held. There has to be finding of facts to support the determination, and then a conclusion along with a rationale around each allegation. It also must include any disciplinary sanctions that is imposed upon the respondent, and whether remedies were designed to restore or preserve equal access to the education program. And then it also must include information about the appeal and how an appeal can happen. I would say that I have yet to see a formal written determination that checks all of these boxes. And so my hope is that with these new rules, we're going to see kind of increased transparency and therefore accountability in how the formal process is working or not working for complainants and respondents. So obviously we are in a very weird time with COVID happening, and this gets to the issue that Rebekah touched on with regards to cyberbullying. But as much as some of us want to be back in school, and maybe some of us don't want to be back in school in the fall, the chances are we are going to have some remote learning in a higher rate than what we've had in the past, particularly going into this school year. So I think we have to always go back to this basic idea of, is whatever is happening in this remote learning process, let's say likely through internet communications or web-based communications, is it impacting the child's ability to access their education? And then you have to ask yourself, again, back to the Davis standard, is the behavior unwelcome conduct that's determined by a reasonable person to be so severe, pervasive, and objectively unreasonable that it's denying equal access to educational activity? You know, if you have a child that is getting kind of bullied in the chat box, and they no longer are coming to the class hangouts, then depending on the nature of that harassment, you may have a Title IX issue that is happening during your remote learning. And one thing I think that is true in all of these processes is that we can't wait until after COVID. So if there was an investigation that starts over the summer with maybe a summer, credit catch-up program, there's nothing that allows for a school to kind of wait until they're back in session, or wait until maybe children are more accessible for interviews or conversations to begin looking at a Title IX complaint and feeling and being on notice if a teacher or support staff is aware of something that is happening through the remote learning process. So some practical ideas. We often see a victim survivor of gender-based violence or sexual discrimination be the one who is the most eager to leave the school, change a class, and frankly to run away from the harm that was caused by the respondent. And now that the new rules are so deliberately concerned about conflicts of interest, I think that as a school, with having people not wearing multiple hats, there's an opportunity here to talk about how a school can maintain trust and relationships with the families that are going through this. Often, I think when we see a district where people are wearing multiple hats, it becomes very difficult for there to be a level of trust and relationship building despite the experience of the complainant's family with what's going on in the school, because there's so many conflicting interests. So I think that practically speaking, with these conflict and free folks moving through the Title IX process, there is an opportunity for people to kind of be designated to maintain a relationship with the family and work on rebuilding that trust. Even if the victim survivor wants to be the one to leave the school or leave the classroom, knowing that it just may not be feasible, there has to be some thought about how that family is going to remain part of the community. There's also, with a burden of collecting information really on the school, there also has to be conversation around maintaining the privacy of the complainant. I think that when parents are feeling really protective or maybe defensive, there's an interest in providing all the information to the people they see in a position of authority. And they may honestly be oversharing with things that you all don't need, from the district side, need to know in order to evaluate what's going on. And there's a risk of, frankly, getting information that cannot or should not be shared. And so with the ability for both parties to inspect, I think it's really a way to build relationships with families by making sure that information isn't obtained that isn't necessary, and that any information that is obtained is done with proper consents in place. I think that can be especially tricky with tweens, especially when the privilege starts to shift over to the child and not with a parent. RMVLC offers an entire program about privacy and advocacy, and if we could be of help to you and your group regarding that, we'd be more than happy to supplement. There were lots of questions around Title IX and engagement with law enforcement. Again, this could be a longer conversation, but there are some things to think about. One is that the advantage of Title IX that law enforcement doesn't have is that with a Title IX potential complaint being identified and the school having notice, is that there can be an immediate positive impact for a student in their day-to-day life. And the disadvantages that are particularly true with the changes of the rules are that every word counts. So every time a child is interviewed, a child is questioned, whether that's in the school or by law enforcement, first of all, no human being ever says anything the exact same way twice. And it does open up the child for further cross-examination, whether that's through the Title IX process or through law enforcement. And so I think that law enforcement and the school have to be really thoughtful about how many times they're going to be asking this child to repeat their words. It not only can make them more susceptible to cross-examination, and unjustly so, but it also re-traumatizes them, and that's not fair. The other thing is privacy. We touched a little bit on this practical ideas about how you maintain relationships and trust with a family that's going through this, but law enforcement too also has to be aware of whether or not they're getting everything they need, or are they getting too much. Cell phones are a big question around privacy, and making sure that, you know, is there a certain text message string that's necessary, or is it really necessary to obtain an entire phone dump or data dump from a phone where there's information that is wholly irrelevant, but is potentially accessible and frankly not relevant and not fair for anyone else to have. And then the last thing is just, of course, how trauma informed is your team. You know, this piece about equity that comes up so much in the new rules and then the 2,000 pages of interpretation really focus on equity. And the message seems to be that some of the well-known dynamics around domestic violence or intimate partner violence and sexual assault is somehow biased against a complainant. Biased against a respondent and to the benefit of the complainant. And I would encourage that in this, rather than worry about bias, the question is your team trauma informed? Does your team know how to, respond to a mandatory report in an appropriate way? Does your team know what questions you have to know the answer to, and questions you don't need to ask to begin with? And often this is, especially for kids, where law enforcement takes the lead. but Title IX still has this advantage of getting kind of immediate solutions in place for the student in order to maintain their schooling. So that might be a little convoluted. It's a lot to pack in on one slide, but it's, you know, these things have to, if we're not trauma informed when we're talking to children about their experiences, then we're doing them a disservice, whether they're the complainant or the respondent. So it's something to think about when engaging your team and thinking about how you're going to handle these situations. There was a question about who should take the lead, Title IX or law enforcement. They can easily go hand in hand, but they cannot hide behind each other. So everyone must continue to work on their respective tasks and be mindful of, again, how much trauma is your team adding in its procedures and policies, and when is it more appropriate, or how much do you need to do your job around privacy? And then Title IX accountability, there was questions about what avenues exist to hold schools accountable. As I said, you know, Title IX and law enforcement reports, especially in K-12, usually go kind of out of the gate at the same time with two different tasks. But a failure by the school can result in a Title IX action through a civil lawsuit, and meaning that the school either failed through its policies or failed through its procedures. And then also they can be, schools can be held accountable through the Office of Civil Rights. We do Office of Civil Rights work where we file a complaint following a poor Title IX process. However, no school has ever lost federal funding for failing to do a good job with their Title IX process, which is probably comforting to districts, but very upsetting often to survivors. And with that, I'm going to switch it back to Rebekah.
Thank you, Alexis. Could you just advance one slide?
I give control to you, but I can take it back if you need it.
Let me try another way. I've got it now. Whoops. Yes. Sorry about that, everyone. And I apologize that we've gone over. We did have technical difficulties at the beginning, but we're very close to wrapping up. I wanted to give some next steps for districts and schools. The first few we've really already talked about: establishing your Title IX team, updating your policies. After you update those policies, your board will need to adopt them. You need to update your grievance procedures and have your board adopt them. We talked about the posting requirements. In addition to posting those 4 required items, you need to widely distribute that information as well. So that includes things like student handbooks, parent handbooks, employment information. Basically, any paperwork that is going out to the school and wider community needs to have your non-discrimination policy, Title IX coordinator contact information, and at least a website as to where they would find the longer information, such as the full policies, the grievance procedures, and Title IX training information. Your next steps then would be to train your staff and any collaborators to educate your parents, students, and the wider community, and to maintain those records for 7 years minimum. So with regards to who to train or educate, you're going to have to train your Title IX team and the various people that are holding those different roles. Your employees, and your collaborators. And that would include things like safety resource, not things, people, like safety resource officers, any school-based advocates or outside trainers that you use. Your students, parents, and families, as well as the wider community, also needs to be educated on what the new regulations say and how the process looks specifically for your school. With regards to what to train on, those definitions, particularly the definition of sexual harassment, is key because you know that students will have a different interpretation if they're not told exactly what the definition is. If you have your definition for sexual harassment under Title IX, but you are including other things under a wider school code of conduct, then your students and parents are also going to know, need to know those criteria under each of those things, whether it's under Title IX or whether it's under the code of conduct. Likewise, updated policies and procedures your employees will need to be trained on and your students and families will need to know about. Obviously, these trainings are going to be differentiated according to the different roles that people have. Your Title IX team in particular is going to have a more in-depth training that includes the scope and the scope of the district's education programs or activities and what it will look like for their particular role. So a Title IX coordinator's training may be different than an investigator's training. And I would say these trainings shouldn't be a one and done, but definitely ongoing and in multiple formats. Now, we did receive a question about logistics in assisting families to understand the new rules and procedures. So when you think about student level education or parent level education, you definitely want the language to be student friendly or parent friendly. And students and parents need to understand, like I said, what sexual harassment is under Title IX versus under your code of conduct. You might include other things under your code of conduct. They also need to know what their child's rights are, such as the right to an advisor and what their role as a parent will be in the process. So, for example, whether the school will notify them before interviewing their students and what the process would look like for formal versus informal. They need to know where the grievance procedures are posted and their right to supportive measures. As we mentioned earlier, they need to know who the district Title IX lead is in addition to the school level Title IX person, what the process is for appeals, and record keeping. Parents want to know how the records will be kept and whether or not they will follow their child. I know I get that question a lot from parents whose child is the respondent, that they are concerned about that record following their child. Just some practical ideas on how to train. We talked about how different people in different roles may have different needs for training. In particular, your Title IX team, I would recommend that you use a Title IX law firm to do that training. The one I am most familiar with is ATICSA, which is the Association of Title IX Administrators. They have specific trainings that are multiple days long according to each role. So when people call and ask me if my 1 hour training counts as being trained, I would say that OCR would probably not consider my 1 hour broad brush overview as being trained at all. ATICSA's Title IX coordinator training is like 4 days long. Their investigators training in face-to-face was 4 days long. Now, in the current situation we're in with things being virtual, I'm not exactly sure how it looks. But I would look to those types of organizations to make sure that you have very in-depth training for your Title IX team members. And from there, you can think of it as kind of a trainer of trainers model in that your Title IX team can then be used to train other employees and collaborators. Those other employees and collaborators aren't going to need the same depth that your Title IX team has received. But that team can pick out the pieces that apply to them and then tailor it to your individual school and district and integrate in, this is what it looks like with our school procedures. Likewise, that team or other school employees can be the ones to educate students and parents. And Alexis, this next slide is for you.
All right, so we had some questions about how to proceed with in the new Title IX world, if folks wanted to work from a victim-centered approach. I touched on this a little bit in the prior slide, but with this idea of making sure that things are equitable, it is for those of us who worked on the advocacy side for complainants and survivors for a long time, it seems as though this is in order to prevent victim-centered approaches to Title IX investigations. So I think it really does come back to this idea of how to be trauma-informed when you're dealing with both the respondent and the complainant. It must be really accessible, as Rebekah was touching on, so that even folks who would normally not feel like they could engage in this way with a school district, because it seems very daunting to many, that if the Title IX procedures are accessible and the training information is accessible, they have a meaning that what you've used to train your staff is accessible, that it is a way for survivors to feel like they might be able to get through this process. And then there was a question about, how do we continue to foster an environment where students, where you're basically being proactive in stopping sexual assault and sexual violence in schools. And I think that comes, and this is not legal advice, but it comes from schools supporting student activists, whether it's, a club that wants to talk about bystander intervention, whether there are other groups within the school that really want to bring more information to the wider student body around intimate partner violence. These are all ways that schools can still try to foster an environment that is opposed and proactive around preventing sexual assault. So those are just some things to think about, ways to walk this line around being, equitable between the parties, but still acknowledging that there is a disparity in between those who suffer. There's a disparity in access and resources between those who are discriminated against on the basis of sex and those who are committing that behavior within schools. And then, so lawsuits and advocacy, we had a lot of questions around like what else can be done. And I think it's important to know that when the new rules were promulgated, the Attorney General here in Colorado did file a lawsuit. This is a link directly to the complaint, but there's been news coverage about it. If you weren't aware, you should check it out. There are basically 10 grounds upon which the AG brief was filed. It acknowledges or argues rather that the new rules reverse decades of effort to end the corrosive effects of sexual harassment and equal access to education. The new procedures put new barriers in place and discourage students from making complaints and seeking accountability. There is a conflict now between our state statute, which is SB 007 from 2019, and the federal rule, that basically the rules were not responsive to the notice and comment period and therefore arbitrary, and that it will chill the reporting of sexual harassment and make it harder for schools to reach fair outcomes. And that in a way, our Attorney General also argues that the rule incentivizes schools for not they say it in a more complex way, but here I'm trying to make it more simple. Incentivizes schools to not respond to sexual harassment in a way that is effective. And they also argue that the rulemaking process itself was flawed. So it's a little nerdy, it's a little long, but if you want to check it out, please do. There's also a Title IX advisory committee that came out of SB 007 that you can keep track of here in Colorado as they help Colorado navigate the new rules. With regards to intersection, we know that sexual violence and we know that frankly there is a great intersection of Title IX issues with students with disabilities and children of color within our school districts and transgender youth, and frankly that we know it's already underreported and not being thoroughly addressed by Title IX. And so I think we all need to have our eyes open to the fact that we can do a better job utilizing Title IX to support students in schools, especially when there is this intersection. And back to Rebekah.
Thank you, Alexis. We did have some requests in addition to the questions. People requested sample policies and training. Certainly, we were able to provide some overview type training, and you can look for some overview type training from me in the future. But again, the in-depth kind of training that the OCR requires for your team to be considered quote unquote trained is something you will want to look to a Title IX law firm or a TCCASA for. With regards to sample policies, for those of you who are CASB members, I did want to let you know that CASB is already starting this work, and I am collaborating with CASB to provide resources and further support over this next school year. With regards to recommendations for student code of conduct or a flow chart of Title IX procedures that reflect the changes, that's nothing that I have at this time, but I did want to acknowledge that I saw your request and that I will keep these things in mind and let you know that I am working with CASB. We wanted to also leave you with some resources. This is the link to the Title IX homepage on the Colorado Department of Education website, as well as the sex-based harassment page. The sex-based harassment page does have links to this new rule where it's filed in the Federal Register, as well as to a summary document. And there might be some other resources there. I'm having trouble at this point remembering what I've emailed to Title IX coordinators versus what I've posted. I've also posted the links here to Alexis's organization. Alexis, do you want to speak to these links?
Sure. So this is just a link to our services, and I'm not sure. The Rocky Mountain Victim Law Center is going to handle Title IX, and then the Legal Information Network is for survivors of crime that are in need of other civil assistance outside of the criminal case.
Thank you. Sorry to catch you off guard. I just pulled those right off of your email. And our email addresses are actually at the beginning of the PowerPoint, not the end. But I'm going to turn it over to Maria, who will give you some next steps on further questions that you might have, how to submit those, and then she will be sending the PDF of this PowerPoint to you, so you'll have these links as well as our contact information.
Yeah, for sure. Thank you both for this really great information. We did have a lot of questions come in through the questions chat box. I am saving those for all of you who asked a question and didn't hear it answered just because of time. Like I said, I am saving those, and we're going to get those answered either by connecting you to Alexis and or Rebekah, or CCASA will get those questions answered for you as well, and we'll send those out. You can also email me if you have questions that come up after this. You can email me at maria@ccasa.org. That's CCASA.org. I did put that in the chat box. And then I also did put both Alexis and Rebekah's contact information in the chat box as well. So feel free to pull from there. You'll also have the PDF where all of the links will be clickable. So you'll have that as well. I want to take this time to thank you both. I know both of you are probably really busy with, these new changes. And so we really appreciate you taking this time to be on this panel, gather all of these questions and answer those questions in a really nice, concise way. So thank you, Alexis and Rebekah, for that. Like I mentioned, any questions not answered, we're compiling those and we'll be following up with you. Look out for that email containing the PDF, and we'll also be sending out information on how to access this recording as well. In the chat box, I also put information about our campus meeting. It's our annual campus meeting for both higher ed and K-12. So if you wanted a little bit more information about that, we have Carrie Simon, who's a leading Title IX attorney, and Rana Simmons, who's our director of policy here at CCASA. And I did put a link to register and learn more about that in the chat box as well. So that's, again, July 16th from 9 to 12. We hope to see you there. Thank you all for being here. Thank you for hanging in with us through the technical difficulties and through the slight extension of our planned time for today. So one more time, thank you, Alexis. Thank you, Rebekah, for your knowledge and your time with us today.
Sorry about the technical difficulties. That was my fault.
No, it happens. So thanks, everyone. Thank you.
Thanks.